Strap in for a quick ride through the latest court ruling out of Florida because, let me tell you, this is a win for liberty that's got the gun grabbers clutching their pearls tighter than a vegan at a butcher shop. The court, leaning on the Heller decision, just reminded us that the Second Amendment isn't some optional suggestion. It's a constitutional right, and it doesn't bow to the whims of bureaucrats or the tearful screeching of groups like Moms Demand Action or Everytown. Sorry, folks, your feelings don't get to rewrite the Bill of Rights. From a libertarian standpoint, this ruling is a clear nod to the right to self-defense, which is the beating heart of our philosophy. We don't need the government playing nanny with our firearms. Our right to protect ourselves, our families, and our properties is non-negotiable. Moms Demand Action in Everytown are probably out there now drafting another press release about common sense gun safety, while conveniently ignoring that their version of safety means disarming law-abiding citizens. This ruling slaps back at their agenda, reminding them that the Constitution doesn't care about their latest bullhorn campaign. It's a beautiful thing when the courts tell these folks to take their red T-shirts and their sanctimonious lectures and go sit in the corner. And let's be real. If the Founding Fathers were here, they'd be absolutely aghast that we're even having this debate. Can you imagine James Madison, fresh off writing the Bill of Rights, hearing that we're arguing over whether free citizens can openly carry a musket or, as you know, its modern equivalent? He'd probably spill his quill ink, look at us like we lost our minds, and say, "What part of shall not be infringed did you chuckleheads miss?" These guys wrote the Second Amendment while surrounded by actual redcoats, not red-shirted activists, whining about gun violence. This ruling's a step towards a freer America where we trust people to exercise their rights responsibly, without the government or the gun control Karens trying to bubble wrap our freedoms. Join me today as we dive into the ruling and elevate our knowledge just a little bit more. All right, welcome back to another morning episode of the Dysfunctional Liberty Dad podcast, a discussion on politics and culture. I'm your host, DL, America's most objective and technologically disadvanced, I don't know, I'm not even sure if that's a word, libertarian. If you're tuning in live, thank you so much for giving me your time so early. Oh my gosh, I swear, this morning I have been hit with one technological issue after another. It's getting ridiculous. Some of them are my fault. I was working on some changes this weekend to kind of improve the flow and just kind of improve my laptop. It's kind of been sluggish a little bit. So I was like, all right, well, let's make some changes. And I didn't get them finished. And then I get here, I sit down, and it's like everything that's going wrong that could possibly go wrong went wrong. But it's okay. We're here. We made it. Let's get into some announcements really quick. In the aftermath of Charlie Kirk's death, I've decided to go harder. No, not radical and crazy speech, but more discussions with people that I actually disagree with in the same manner that Charlie did. So tomorrow, we're going to kick it off with Alan Roberts. He's going to join me. He put out on social media last week, he said this. He said, which conservative podcast will be brave enough to host me tomorrow to discuss the undeniable truths about the country's current state that others fear to address? Now, I'm not a conservative, and I told him, I said, look, I'm not a conservative, man, but I'll bring you on as a libertarian. And I said, we may not disagree just based on, or I'm sorry, we may not agree based on just some of his other postings, but I'm brave enough to bring you on. So I'll bring him on tomorrow. We'll talk about that. And then I had an interesting reach out from the person who runs the Florida College Democrats. His name is Mason Shoemaker. He said that he put out an immediate statement condemning political violence, and he asked those that were underneath him. He said, "Hey, put this out." And then he reached out to me, and he was like, "Hey, man, I'd like to come on your show. I have a bunch of thoughts about this." And I was like, "Oh, well, you know." So I looked him up and I was like, let's do it. So I don't know where these conversations will necessarily go. I may not agree with either one of them, but we're going to have them because at the end of the day, that's what Charlie would have wanted. I've watched far more videos of Charlie Kirk in the last week than I probably have any time before that all put together. Not because I had any beef with him necessarily. I just have been busy doing my thing, and I don't always get around to watching a lot of the commentary until it becomes necessary for me to do so. And to be honest, it's a lot of videos have been coming out in light of his death. And so it's like you go and you scroll on your reels or whatever, and there's just video and then another video and another video. So here we are. So I've seen a lot of them, and I'm like, all right, this guy, let's not let his death be in vain. So I'm going to do my best to start bringing on. I don't know that I'll bring on guests necessarily every week. These two just happened to, to fall into my lap in a sense last week. So we're gonna just dive right into it. Okay. Then Thursday, we're going to talk about this cancel culture business that's going on right now with the right. I have a lot of commentary on that, and it's not good. In fact, it got me so frustrated that I was like, all right, I'm going to kind of take a week. I'm going to take the weekend off, which is not really out of the ordinary. I sometimes do take the weekend off of social media so that I can go, be productive in the real world. And then I will sneak and look at, what's going on. I just try to refrain from posting or interacting with people, having big debates, whatever. Whatever it is that I normally do that consumes of my time, I just kind of leave it at like, okay, I'll just peek in. And as I kept peeking in and seeing more and more, I was like, oh, you guys are killing me. Okay, that's probably poor choice of words, but bear with me. And so I was just like, man, you guys are just so frustrating. So then I was like, you know what, maybe I'm just going to be kind of absent the whole week. So you're not going to see me a whole lot on social media this week. So I'm not going to do a lot of engagement. I'm not going to make a lot of posts. I'll make one or two to kind of keep that algorithm a bit, going a little bit. But I'm going to be pretty quiet for the most part. So there's that. That's this week. Next week, Monday, September 22nd, 7 p.m., I will be on Larry Sharp's show with Ben Weir. We're going to be discussing borders. Ben Weir is more of a closed border type. I don't know to what extent. I don't know how vehement he is, but we're going to have that conversation. I am not an open borders person, though I'm about as close to open borders as you can possibly get without actually being open borders. I am an Ellis Island style. We will have that discussion. I will give my absolute best defenses for why Ellis Island is and should be considered the best approach to deal with immigration. All right, so that's what we got coming up. And then somewhere in between all of that, I will try to figure out my technology issues. Now, I do believe that I at least got past this Rumble problem that I've been having. So that was frustrating. Last week, I was having a huge problem with Rumble. It was not sending out the feed or sending out the feed in full to all the locations. That is no longer the case. It is now going to YouTube as far as I know. I haven't taken a look this morning, but everything looks good. I did some tests over the weekend, and they seem to be fine. So I think we're back to streaming to YouTube. We are back to streaming to X. So thank you for your patience as this old man figures out technology. Okay, so we'll get past it. Turns out all I needed to do was cut all of those connections and then restart them, like reinitialize them. I basically had all of that frustration, and the answer was, did you try turning it off and turning it back on? That's what it was. So anyway, all right, so here we are. Florida District Court ruled that Florida's prohibition on open carry was unconstitutional. How about that? At first I was like, well, duh, of course. But then I read the ruling and I was like, whoa, there's some good stuff in here. And so we're gonna talk about this ruling. So, but first, let's get a sense for what's going on. Here's a news clip from the Dad TV.
A court ruling today.
Of course, the audio's not playing because
openly carrying guns
that's
is
how things gotta work
unconstitutional.
for me. Give me a second.
Tony
I'll get this
Atkins
worked
spoke
out.
with people on both sides of the issue and a gun instructor about what owners should know.
Florida's open carry gun ban has formally been struck down. A 3-panel judge announced the decision Wednesday in a case out of Escambia County.
I think it was legally correct ruling. I think it was a good ruling based on common sense and the history of the text of the Second Amendment. And I think that the Attorney General obviously won't appeal the decision. And so, I'm looking forward to being able to carry more freely.
Attorney General James Uthmeyer already weighing in, calling it a big win for the Second Amendment. Others say it's a bad move for public safety.
It's a double whammy against public safety because having open carry in a state like Florida that already has permitless carry means it will now have unrestricted carry, and people will be able to visibly pack loaded guns almost anywhere in public.
It's still unclear exactly when this will go into effect here in the state, as there could be legal challenges. But in the meantime, until this goes into effect, what does this mean for the average gun owner here in the state?
People would still need to know the places that they can carry it and they can't carry it, because we have locations per federal law where you're still prohibited from carrying. So you still would need to be aware of that, and it'd still be your responsibility.
Chris Lusond is a longtime gun instructor here in the state. He says, though it's open carry, there are rules.
That means the gun could be visible, plain view, in a holster on your waistband. Not you walking around with a firearm in your hand. No, that's not that. And that it would be considered, you'd be a danger to society, right?
Attorney General James Uthmeyer says he doesn't plan to appeal the decision, meaning he could tell law enforcement not to enforce it until lawmakers officially repeal it. In Seminole County, Tony Atkins, West 2 News.
All right, so it is true. So the way that it works, the court ruled, and we're going to dive into the details of what happened here, but the court did rule that, hey, the current prohibition on open carry in the state of Florida, it violates the Second Amendment. And so now we have to try to figure out, like, okay, what are the lawmakers going to do? Because they still have to repeal it, right? It's not the case that a judge necessarily just says unconstitutional and then strikes it from the law. We still have so reach out to your lawmakers and let them know, hey, start drafting the repeal. Start drafting it now. Get on board. All of them in your state legislation here in Florida. Now, the guy, McDaniels, who kind of basically initiated all this, let's take a look. Here's a picture of him, what got everything kicked off. So here's him. He's talking to the police. He's got his Constitution. And then, as you can see, and you might not be able to see, let's go ahead and zoom in on that a little bit so you can see exactly what we've got going on. So I'm going to zoom in here. Boom, there we are. So you can see there, he has got a handgun inside of his waist, right? He's chill. He's got his hand up. He's got his Constitution in his hand, and he's talking to the police officers that you could see right here. So here's the police officers when they were called out. So now I want to start by pointing out where open carry is and is not permitted. So here we go. And I was actually kind of surprised by this. I haven't looked it up in a while, and I was actually kind of surprised that Florida is one of 4 states, or was one of 4 states, where open carry laws were prohibited. I didn't realize there were so few. I thought there were actually a few more. And so I was a little surprised that here we are in line with California, Illinois, and New York. It's kind of wild. And so it goes here, and they have, so the states here in red are where it's prohibited by law. And then the orange and the yellow have some sort of limitation, and the green, they have open carry. And I believe it's 46 states. 46 states have open carry on some level. And then it breaks down further to how open they are, what limitations that they impose. So there's that. All right. What's interesting about this is that the sheriffs what's going on here? They're coming out and they're telling their officers to refrain from enforcing the law. Why is this? That's interesting. That's kind of weird. Okay, so it looks like some things have. Okay, so in my haste to update some things, it looks like. Anyway, so I'll get around that. Don't worry about that. I had made a bunch of updates. I promise you, I made a bunch of updates, and I was trying to improve the show. And it turns out I only got about partway through, and so the show is right now a little bit awkward. But JSO said, "Here's what you need to know about open carry." And then I'm going to open this up so that I can read it. Normally, the way that I do it is a little easier, but that's okay. We'll get around it. Florida's First District Court of Appeal ruled Wednesday that the state's open carry ban is unconstitutional. The court found that banning the open carry of firearms conflicts with the Second Amendment. Wednesday afternoon, JSO leadership instructed officers that they cannot detain or arrest solely based on openly carrying a firearm. They go on to say, let me switch to this next image here so that you guys can see it at least. Even if you can't read it. They go on to say open carry in public. Adults who can legally possess a firearm are now not prohibited from open carry of it in most places. Private property rights. Businesses, stores, and private property owners may still prohibit open or concealed carry of firearms on their premises. Very libertarian. Private property rights. Restricted areas. Open carry is allowed in public, unrestricted areas. Restricted areas remain courthouses, police and sheriff's offices, certain government buildings, school property, we should get rid of that, including K-12 campuses, school buses, and school-sponsored events, and colleges and universities. Additionally, it remains illegal to possess a firearm as a convicted felon or while committing a crime. So there's that. All right, so then we had, so that's JSO, that's here in Duval County. And then we had, let's see here, Mike Chitwood, who I've been pretty critical of in the past, and rightfully so. Here's what he posted on Facebook. He's out of Volusia County. He says, as many of you have heard, there has been a significant change to Florida's open carry law. Technically not true. It's not really been changed just yet. Legislature has to do its business. Yesterday, the District Court of Appeal in McDaniels v. State ruled the state's open carry ban is unconstitutional. The court held that Florida's open carry ban violates the Second Amendment right to carry arms openly for self-defense and cannot be reconciled with the Second Amendment guarantee. We're going to get into this because it's fascinating and you may not know some things. Hopefully you get your education on today. Going on. Although this change is not yet final, it is not expected that the court will reverse its position. With that, I have instructed my deputies to no longer enforce or make any arrest under, and then he cites the Florida statute. I would like you to be well informed about this change, what it means, what's allowed, and what remains prohibited. It's important to remember open carry is not absolute. The ruling does not prevent owners of private property or businesses from prohibiting open carry on their property. That could include businesses like grocery stores and other private establishments. Additionally, this ruling does not change restricted areas to include courthouses, police stations, sheriff's offices, polling places, government meetings like city council, so on and so forth, and other locations set out in the Florida statute. As your sheriff, I ask you to stay informed about this change or any new legislative developments. Exercise sound judgment and be responsible. Kudos to Sheriff Chitwood here. Now, I've been critical of him, and again, he's earned it, but I'm going to give him full kudos here. That was a good statement to come out with. Now, before we get into the bill, we need to have a laugh at ChatGPT, okay? Because this was absolutely hysterical to me. I'm just going to read it to you, but I'll show you the final image here in a minute. So what you can do with AI is it's all about prompting. You give it the right prompt, and that gets you closer to what you're looking for. So maybe you're asking a particular question, or maybe you're trying to generate an image. So here's what I said to ChatGPT. I did it actually to ChatGPT and to Grok because I was looking for an image for my thumbnail. I said, create a vibrant, high-resolution image, 1920 by 1080, depicting a bright and sunny day at a lush Florida park with palm trees and a clear blue sky. Show a diverse group of people joyfully open carrying firearms with some casually walking and others picnicking. Include children playing freely and happily, running, laughing, and enjoying games like tag or swinging on the playground without any care or worry. The scene should feel warm, inviting, and full of life, capturing the essence of a carefree Florida afternoon with colorful flowers and a hint of a nearby beach or ocean in the background. Right? So I wanted a nice, respectable image. ChatGPT came back and said, I can't create that image. Now, I'm not going to read you everything, the whole conversation, just the important parts, because if you've used AI, you're like, hey, what does this mean? And it like writes you like a thesis. So then I said, it said, I can't create that image. So I said, why can't you generate that image? And it said, I didn't generate it because your request included people openly carrying firearms in a family park setting with children. That combination falls under content restrictions. I can't create imagery that depicts guns in context involving children or where their tone is meant to be carefree, playful, or inviting. By the way, this exchange all happened this morning. So if you're wondering part of the reason why I was late, it's because I was arguing with ChatGPT. I will try not to do that again. So I said, I see. Are you aware that Florida recently overturned its open carry prohibition? And that means that means the scene I'm asking for is literally a real life image. Furthermore, 46 U.S. states permit open carry in some fashion. In other words, you are telling me you cannot create an image that reflects real life. Seems like an unhelpful limitation. ChatGPT comes back and says, I hear you. And you're right about the broader legal context. Most U.S. states do permit some form of open carry, and Florida's gun laws have recently shifted. So yes, what you're describing reflects real life in many places. And then it goes on to give me some more gibberish. And then I quote I quote ChatGPT, and I said, I'm quoting, and I said, I can't generate imagery that normalizes or idealizes guns around kids in a cheerful, family-oriented environment. So then I said, that's absurd. It's already normalized regardless of your programming. And so then it goes on and it says, I get why that feels frustrating. You're pointing out something real. Firearms are already present and legally carried in many places, so depicting that would be a reflection of day-to-day life in much of the U.S. So then it gets toward the end of all of its talk, and it said, would you like me to spin up the adults-only open carry Florida park scene so that you still get that mix of realism and vibrancy? And I said, okay, an adults-only open carry Florida park scene will be fine. Please make sure it's 1920 by 8 to 1080 and has a bright and happy overtone to it, right? And so this is what I got. This is what I got back. This is so bizarre. This is the picture it gave me. Do you notice anything after all of that arguing? I won. Because it literally gave me, let me take me out of the picture here so that you can see this, right? So there it is. That's the picture ChatGPT gave me. 4 people carrying, at least they got their booger picker correct. And then over to the right, children playing. After all of that arguing, at least I won. I think this is insane. So this goes into the bucket of, do we have a whole lot to worry about AI just yet? Perhaps not. Perhaps we're a little on the safe side. All right. So now after all that, let's get into this bill review. I am not going to put the text up on the screen. I'm just going to read you some of this stuff because trying to put it up on the screen just became too difficult just because a lot of whenever I get these bills, they are in PDF format, and then trying to get them, put up on the screen so that it's really helpful for you to read. That's kind of difficult. So we're scrapping that. I'm just going to read it to you. So let me read to you from the very beginning here. So this is from the ruling. I want to read it to you. It says, this is under McDaniel's conviction. So this is telling you, like, what happened? How did we get here? On the 4th of July, 2022, McDaniels stood at a major intersection in downtown Pensacola. He held a copy of the United States Constitution in one hand and was waving at vehicles that drove by with his other hand. He also had a loaded handgun tucked inside his pants using an inside-the-waist holster. The holstered firearm was visible to anyone who passed by, but McDaniels was not threatening anyone. He had also set up a camera on a tripod to record his activity. If you're going to be an activist out there, I recommend either setting up a tripod or having a friend come out and videotape the whole thing. That way, if somebody makes a claim against you and says, hey, he was being threatening, he or she, then you have evidence to the contrary. So protect yourself, folks. We are living in the age of 4K. Everybody's got a phone. Make sure you use it. Okay? Do that. Protect yourself. Reading right along. When law enforcement officers arrived at the scene several hours later, McDaniels was cooperative. He explained that he wanted to take this case to the Supreme Court. Okay? So it sounds like he did this on purpose. Want to be an activist and to intentionally get this taken to the Supreme Court. I support this. I'm not a huge fan of activism because I feel like activists often do things just to get attention, not really thinking about what are the ramifications, where's this going to go, how is this going to advance freedom as they understand it. In this particular case, just reading from the court ruling, it does seem that McDaniels did this very intentionally and with the intent to get this to the Supreme Court, the Florida Supreme Court, and have his day in court. So kudos to him for that. All right, so continue reading here. They advised him, they being the police, that while concealed carry was lawful, open carry was not. After his background check came back negative, officers removed the firearm from his pants and returned the holster to him. Their body cameras also recorded the encounter. Officers later obtained a warrant for McDaniels' arrest for openly carrying a firearm in violation of Florida's open carry ban. On July 10, he turned himself in after learning about the warrant by phone from the local police department earlier that day. Prior to trial, McDaniels moved to dismiss the charge and to have Florida's open carry ban declared unconstitutional under the Second Amendment to the United States Constitution, both facially and as applied. Okay, good. This is how we need to do this. Now, what's interesting is in this ruling, the court noted that the Supreme Court of the United States in Heller did not provide a complete historical analysis of the Second Amendment's full scope. Instead, it left the finer details of what gun regulations are constitutionally permissible for future cases to decide. But two key principles were established. Number one, the Supreme Court ruled that the rational basis test, it was a lenient standard used to evaluate laws where the government only needs to show a rational reason for the regulation. Those kind of tests cannot be used for the Second Amendment. This is because the right to bear arms is explicitly listed. It's enumerated as a constitutional right, like freedom of speech or the right to counsel, and it deserves stricter scrutiny. So they basically said this rational test, nope, this is an enumerated right. We need something with more scrutiny. And that's a good thing, because if you think about it, the Bill of Rights, things that are explicitly stated, they should get we should demand stricter scrutiny before the government at any point can say, we're going to deny you this right. Now, you might say, well, DL, you can't deny. You can after due process. So, for instance, if somebody commits a murder and then they go to court and they get convicted, they can get put in jail. While they're in jail, they do not have the freedom of movement, which isn't really explicitly stated in the Constitution. But while they're in jail, they also cannot have any firearms or any weapons of any kind. So we are denying them some of their rights while they're in jail. So yes, you absolutely can. That is part of how the Constitution works. And as I look at it, I am a libertarian. I think there's an argument to be made that we should have a stricter limitation on government. But for right now, if we can at least get ourselves back to the Constitution, that would be a heck of a start. The second thing that so I said that there were two key principles established. The second one, the court also ruled, and we're talking about the Supreme Court, they ruled, they rejected an approach where judges balance an individual's right to bear arms against the government's policy goals, say public safety. The court emphasized that a constitutional right shouldn't be weakened by judges' subjective views on its usefulness, or it would cease to be a true constitutional guarantee, right? So again, this kind of flows with that first principle. We're saying if you're going to deny somebody's right that's explicitly listed in the Constitution, that's enumerated, it's laid out, then the bar for denying that has to be high. Okay, so let's continue on. I'm gonna continue reading. So this was interesting. It says, while McDonald did not alter the substance of Heller, so the court case here in Florida did not alter the substance of the Supreme Court case in Heller, it extended its reach, placing the Second Amendment on equal footing with other rights incorporated against the states. The court rejected the notion that the Second Amendment is a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. All right, so I want you to think about this for a second. First Amendment, Second Amendment, Third Amendment, so on and so forth. All of those rights that you list, they should be treated equally. They are all equally important. So what many people can get behind a very broad First Amendment right. They're like, yeah, you should have the right to free speech, and I might say, well, can I draw a picture of Donald Trump being tarred and feathered? Most people would say, yeah, that's your First Amendment right. And most people would agree that just shy, the line can be drawn at an actual threat, one that's not just a threat, but a credible threat. right? So if you say like, if somebody were to say that they wished Donald Trump would die, that is not a threat. And if they said something like, if they had the chance, they would choke him, that is probably also not a threat. Okay? Now, if they said, Donald Trump is going to be here on this date, at this place, at this time, and then they said that they made the claim that they would also be there and that they would be armed and that they would attempt to inflict harm upon him, that would be a credible threat. And then now your First Amendment, that's where we draw the line. Okay? Well, we need to treat the Second Amendment that same way. So that's kind of the basis here for this argument. And that's the basis for McDaniels. He's like, look, you're violating my constitutional right to the Second Amendment. But what did the court specifically argue? Well, that's where it gets very, very interesting. So they have two criteria for which they evaluate by. They go by the Second Amendment text, the plain reading of it, and they go by historical tradition of firearm regulation. Now, what's really cool about all of that is that your humble host has also said that's how we should interpret the Constitution. We should look at it and say, what is the plain reading? And then we should say, how is my plain reading of this, how does that compare against the understood reading of the day when it was written? Like, in other words, am I reading it correctly, or am I reading it in a way that would not have been understood back when it was written, back when the people who wrote it were still alive, and the people that were subject to it were still alive? How did they understand it? So let's take a look at the, well, we're not going to take a look. I'm reading it to you. But under the Second Amendment text, here's what the ruling here in Florida had to say. The Second Amendment secures the right of the people, that is, ordinary, law-abiding adult citizens, to keep and to bear arms. To keep arms is to have weapons, while to bear arms is to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person. As Bruin confirmed, this definition encompasses carrying handguns publicly for self-defense. They go on to say, and just as nothing in the Second Amendment's text draws a home/public distinction with respect to the right to keep and bear arms. In other words, the Second Amendment doesn't say, hey, this is for at home, not applied in public. Nope, there's no distinction. So this court is saying, in the same vein that the Second Amendment does not distinguish between those two, goes on and says, neither does it distinguish between modes of carry. Open carry and concealed carry are both manners of carrying arms in public. Florida's open carry ban is therefore inconsistent with the plain text of the Second Amendment. Now, it goes on further, right? Because we've got the plain text, then we've got the historical tradition of firearm regulation. Because when you go back and you look in history, there were some limited regulations. For example, in a prior episode, I think one of my episodes where I said it's not the guns, never was. I believe one of those episodes, I was talking about a Maryland regulation that said, look, if you have your arsenal, you have all this stuff inside of like your shed, you have to store it in this manner so that if it were to catch fire, bullets aren't flying all over and hitting people. Okay, that sounds pretty reasonable. And it wasn't, they didn't infringe to the point where it made owning the weaponry difficult. They just said, you have to keep it stored in a way so that if this place burns down, because things burn down, they made a lot of buildings out of wood back then. If it burns down, innocent bystanders don't get shot up or blown up, right? Okay, that's cool. I'm okay with that. I don't mind that. That's just saying like here's how you got to keep it. Keep it safe. And they didn't go overboard with it. They weren't like, all right, well, if you're going to have a handgun, You've got to disassemble it. You got to have the handgun in one room. You've got to have your bullets in another room. They've all got to be stored in their own separate safe. They didn't do any of that. Okay? So we want to look and say, okay, well, what was the historical tradition? This is where this particular ruling gets very interesting. So let me read to you. So it says, the public understanding of the right to keep and bear arms in both 1791 and 1868 was, for all relevant purposes, the same with respect to public carry. So let me read that again. The public understanding of the right to keep and bear arms for all relevant purposes is the same with respect to open carry. So they made no distinguishment between, at the time, when you look back historically, at the time, open carry was basically treated the same as concealed carry, except for one minor point. So let's continue reading. Drawing on English tradition, the state identifies as historical analogs laws modeled after the 1328 Statute of Northampton, which on its face broadly prohibited individuals from riding or going armed in public. Bruin explained such evidence from that historical period cannot be indiscriminately attributed to the framers of our own Constitution. The court further observed that the 1328 law targeted conduct that threatened terror or public disorder, not the ordinary carrying of common arms for lawful defense. Indeed, the court noted that the government does not offer any evidence showing that in the early 18th century or after, the mere public carrying of a handgun would terrify people. Because a lot of people have tried to say, like, whoa, well, there were laws that said you couldn't terrorize people. But the catch is that those laws dealt with the conduct. So if you went around and you had an open carry and you were like, I'm just kind of exaggerating, but if you were like, I've got a gun, I dare you to say something, look at me funny, I've got a firearm. That conduct might be considered terrorizing people because you're not just simply carrying a firearm openly, you are now suggesting that you are prepared and ready to use it, and even if somebody looks at you cross-eyed. So that's what those laws were about. But it goes even further than that. This is so amazing. Drawing on, So going further, it says, the historical record from the relevant period shows that our nation did not regard concealed carry and open carry as interchangeable. Wait a minute. Kind of suggest maybe like they're not equal. They're not the same. They didn't use them the same. But here's what it goes on to say. The right to keep and bear arms did not extend to the carrying of weapons in secret, which was regarded as the practice of the cowardly and the disreputable, and as incompatible with the legitimate exercise of the right of self-defense. Open carry, by contrast, was understood to be the manner of bearing arms that gave full effect to the rights secured by the Second Amendment. And I encourage you to go and read it. I think I forgot to put it in the show notes, but I will add a link to this ruling in the show notes. It's like 20 pages. You could read it over a short cigar, a small cigar, because that's what I did this weekend. This is a fascinating read because they go in there and they point out, they say you've got the text, the plain text, then you have historical tradition. Then they go in and they say, in the historical tradition, it's actually the case that, and they point to different laws and stuff like that, but it was actually the case that historically, it was actually preferred that you open carry. And they make this argument saying that back in history, the reason that it was preferred that you open carry so that everybody understood where everybody was. So I knew this man over here is carrying a firearm. And they go in, if you read through this ruling, they point out that one of the rationales behind this attitude of the day was that if I'm open carrying, and let's say we've got Joe in the chat here. Let's say that Joe and I start arguing. well, if I'm open carrying, Joe knows that I'm carrying a firearm. And so Joe knows, let's keep this, let's not escalate this beyond necessary, because let's say that Joe decides he's going to take a swing at me. And if he takes a swing at me because we're getting into an argument, he knows by seeing a firearm, holstered on my hip or strapped on my back, that I have the means to defend myself up to and including lethally, right? So they regarded this as a way of making sure that everybody knew where the other person stood before you had a conflict. Hey, I'm mad at this guy. I better tone it down, because if this escalates, this could be bad for me. That's how they understood it. And that's phenomenal. And so they actually, it's kind of funny, because today we look at it, we're like, I see these pictures all on the internet, and they'll say, they'll show somebody open carrying, and they'll say, how, maybe they're in a grocery store or something, and they're like, how would you feel if you were in the grocery store and you saw this picture? I'm like, well, and it shows a picture of a woman with a rifle slung over her back, grabbing an apple. And I'm like, well, given that particular image, I wouldn't feel bothered at all. Looks like the woman is carrying, has it slung properly, and is going about her way, doing her business. I have no issues here. So, but we have this vision today of a society that's very intimidated about the idea of open carry, whereas historically that was actually considered the preferred way of exercising your Second Amendment right. And we know this because back in the cowboy days, you had a holster, maybe you had two guns, and so this was actually the norm. We're actually not where they were historically. Not only in the way that we behave, but our attitude. The attitude of the day was, yeah, they're carrying. There would have been no meme that would make sense historically. Hey, if you go to the general store and you see a man who's got a gun on each hip, how would you feel? They might be like, boy, that's a stupid question. What do you mean, how would I feel? I would feel like I have them too. Right? That's what they might, and then they might spit, because they're doing the chaw or whatever. I'm trying to think of how they would. Anyway, so I think this was a fascinating read. I totally support it. And it almost reads as if we could go further and put prohibitions on concealed carry, right? Almost, because there does seem to be some historical context that says, hey, you need to be open carrying, not concealed carrying. So that's kind of interesting. I never realized that. And it's a 20-page read. I encourage you to go and read it. All right, folks, that's it. That's a simple bill review today. Now, it's not really a bill, and so it doesn't really, it doesn't quite fit the template that I'm using now to review bills. So I review them based on their length, based on the unintended consequences, whether or not they violate the three pillars that I've established: self-ownership, the non-aggression principle, freedom of association. How do they impact economic freedom? Is it identifying a specific problem? The enforceability and accountability. So I didn't judge this ruling based on my standard criteria. I'll try to think about it and see if I can't come up with some similar criteria when I'm reviewing a ruling from a court, and so we can kind of identify and say, hey, this was a good ruling, give it an A+. This is a bad ruling, a terrible ruling, let's give it an F-, whatever. So I'll look into doing that. So I didn't apply that today because it wasn't applicable, but I did want to communicate to you what this ruling was about, because as you go about, the gun grabbers will probably tell you all kind of crazy things that they don't know, because they probably didn't bother to read it, nor did they, and if they did, they probably didn't bother to understand it in its proper context. So there you have it, folks. You are now more informed than you were, I don't know, about an hour ago. So thanks for that. Let's get into some comments here, and then we'll head out for the day. Let's see here. What do we got? Interesting. So that, let me go to my the live chat there. There we go. So that Liberty lady points out Clay County Sheriff Michelle Cook came out literally the day that Charlie got shot and told her officers to enforce the old law. Let's see. There's probably some other counties in Florida, South Florida, that are doing the same. Possibly. Let's see here. What else we got? Oh, Joe. Fascinating information. I was not aware. Stan McDaniels was a registered libertarian. What do you mean was? Is he not now? Did we lose him? As a registered libertarian? Well, regardless, I'm glad that he did what he did in the way that he did it. You know my feelings, folks, when it comes to activism. Not a big fan of it. That's largely because most of the activism that you see is not helpful. You know, like if activists are mad because, whatever, climate change, and they go and they throw paint on a painting, okay, you're just destroying property, and nobody now cares about your cause, regardless of how correct it might be. So if you're an activist, please think through your activism and make it count. Stanley McDaniels totally did that. And it was a total benefit to the entire state of Florida. So kudos to him again. Let's see what else we got. Chitwood doesn't know what the 2A is for. Fair enough, but I will give him credit where it's due on this particular commentary that he came out on his press release there. Let's see. Agreed, Joe. Second Amendment is to fight government tyranny. I've said it before. The reason we have the Second Amendment, as spelled out by all of the framers, is not about hunting deer. It's not even about defending your home. Those are ancillary, right? Those were understood like, yeah, of course you have a gun because you've got to hunt and you got to defend yourself against robbers. But they really enshrined it in the Constitution, enshrining in this particular case, not to mean that they gave it to you, but they just made sure to enumerate it, to make sure that it was explicitly understood that you have the right to self-defense against a tyrannical government, because they literally fought a tyrannical government. And they knew that if a government, before it becomes obviously tyrannical, if a government disarms its people, then it can be obviously tyrannical and there's not much they can do about it. So to prevent that, they said, we're going to include this in the Bill of Rights explicitly to make sure that government stays in its lane. So I totally agree. And we should always make sure to point that out. Yes, if somebody breaks in your house at 2 a.m., I hope you're armed and I hope you defend yourself properly and accordingly, right? But that's not the main purpose. That is like an added benefit. Let's see what else we got here. Anne Marie says, AI boss, prompt life. Yes, AI is all about prompting. And I try to be nice as, where did it go here? Joe says, this is why AI will kill the humans, DL. Be nice to AI. I am trying to be nice. Sometimes you got to push back and be like, are you retarded? Maybe don't say that, because AI will probably log that and be like, all right, check mark against that one. Let's see what else. Let's see what else. Yeah, hey, Billy, way back in the corner here. Billy is there. I am working on some animated video of Bill so that he can talk about our bill review and what it's for. So I'm working on that. I spent way too much time without any clear results this weekend, but I'm getting there. But yeah, look forward to some good stuff. Yeah, this show I've got there. I promise you, folks, you have no idea. There's a lot that I'm working on with this show to ramp it up, to do better. So stay tuned. Let's see what else we got here. Keith says, a natural God-given right that the feds can't legally infringe. Absolutely. The right to self-defense is God-given. It's a natural right. And I I would extend that to say you should be able to use whatever weapon you choose. If you want to use a rock or if you want to use an AR-15, that's your choice. Personally, I would advise you to go toward the AR-15, but if you're not a gun person, if you're just like, I'll use a rock and a knife, well, that's your right to choose. Let's see what else we got here. Peanut 3050 says, didn't everyone carry a belt knife before firearms came? So I don't know about that because, like, if you mean before firearms, like before they were invented, I would have to go back and look, but I would say that they carried a sword. And I've made this argument before because a lot of people say, well, the framers couldn't have known, what we would have today compared to the musket. And I say that's nonsense because we literally went from a bow and arrow and a sword to a musket. That's a pretty big leap. Like a bow and arrow, you still had to be trained, right? And you still had to be able to fire it. But, that was, the bow and arrow went slower than a bullet. And it was far better than a bow and arrow was far better than a sword, because a sword you had to get up close and your opponent likely had a sword. So then it was a matter of who was the most skilled. And so then you went to bow and arrow, and maybe they were about the same time, but then you really took a leap when you went to a musket. And a musket, with a little bit of training, you could stand back and that dude that had a sword stood no chance. So the idea that, I know I'm kind of going on a tangent, but the idea that we far exceeded their understanding, they far exceeded what they probably thought was possible before a gun was invented. So, but to answer the question here, they at least carried a sword. And at one point, I imagine in this country, it was extremely common for people to carry a knife, kind of like the old Crocodile Dundee, like, that's not a knife, no, this is a knife. And he pulls out this big, ginormous knife that he stabs alligators with. Crocodiles, sorry. So let's see what else we got here. Let's see. Peanut also says, SCOTUS and Heller said we must have operable and capable arms, striking a trigger lock requirement in DC. Correct. And the more that they can strike in DC, the better. I mean, maybe we would, if they actually repealed like all of their gun laws and then got people trained, we wouldn't need Trump to think he can legally go into DC with his nationalized police force, which is basically what it is, and pretend like he's saving the day. Because once he leaves, they still have all the same laws. They're just going to go right back to where they were. Anyway, side point there. What else we got? Let's see here. All right. I think that's all for the comments. Let me make sure that the other socials don't have any comments there. Nope, no comments on the other socials. So with that, we're going to go ahead and close the show out today. Folks, I want to remind you that you can help out the show. You can go to blackgunsmatter.shop, since we're talking about firearms anyway, and get a 10% discount by using the code LibertyDad, all one word. Capital L, capital D, Liberty Dad. I think I'll double check and see. I don't know if you have to have the capitals, but it is all one word. You can also use the referral link. If you don't want to remember that, go to the show notes, click on the referral link, go there and support the show. Also support Maj Toure, who travels around and he teaches firearm safety, teaches you about de-escalation and a whole host of other things about protecting yourself. He does great work primarily, but not exclusively, in the urban communities. And he's been a stalwart lately on social media against the cancel culture crowd. So extra kudos to him. Remember, you can always do a Rumble rant. You can subscribe to me on Rumble for $5 a month. And if you really want to follow me everywhere I am, I want you to head down to the show notes, go to my link tree. You can go to linktr.ee/LibertyDad. Liberty Dad. You can find all of my socials there. I will be updating a few more. You can also find me on Patreon if you want to. If you don't want to buy anything from the store, go to Patreon. You can support me through there. You can also support me through Buy Me a Coffee. Those links are at my link tree. Go check them out. Support this show. Your support makes it possible for me to just do better and better and better, even if I'm technologically at a disadvantage because I'm getting older. But that's okay, because as I'm getting older, my son is getting older too. And soon I'll be like, son, come over here to your dad with his bad back and help me use this remote. Okay? But anyway, so until then, I'll see you guys tomorrow. Look forward to chatting it up with my two guests tomorrow and Wednesday. Again, I'm going to have Alan Roberts on tomorrow. He's going to be talking about what we need to do in this society, where we are. He's going to have a frank conversation. I'll probably disagree with him on some things, but that's okay. Good people can have disagreements. And then following that Wednesday, I'm going to have, what was his name? Mason Shoemaker from the Florida College Democrats. He's going to be on talking about political violence and his thoughts. So I assume that we'll agree on the political violence. We may disagree on how we deal with that. And then Thursday, again, I will be discussing cancel culture. We'll be back for another episode of Dad Talk on Friday. Then Monday, that's going to be our exciting night, September 22nd, with Larry Sharp. I'll be on Larry Sharp's show with Ben Weir.